Good afternoon. Welcome to Grace and Gavel, where truth meets compassion. My name is Buffy. I'm an almost 18-year criminal defense attorney who practices in the area of criminal law. Today we're talking about when a fight isn't a crime, the law of mutual combat. Welcome to Grace and Gavel, where truth meets compassion. It is a true crime podcast where legal concepts meet reality, real-world cases. Today, we're diving into a question that surprisingly many people ask after watching a viral street video or hearing about a barroom brawl. Can two people agree to fight and not be charged with a crime? The shorthand legal phrase for this is mutual combat, but the reality is actually more complex. At its core, mutual combat refers to a consensual physical altercation between two people who willingly engage in a fight. Think of two adults agreeing. Let's take this outside, and then exchanging blows. In theory, in some parts of the U.S., this doesn't automatically mean a criminal case can't be brought. But consent alone rarely allows for immunity to the participants from the law. What is mutual combat? We're talking about the black letter law definition, which stems from common law from England and all that history. So in legal discussions, mutual combat is generally defined as a situation in which both parties purposely and willingly engage in a fight on relatively equal terms. It differs from classic one-sided assault where one person is a clear aggressor and the other a non-consenting victim. However, consent isn't always legally meaningful. Jurisdictions still treat the fight itself as an assault or breach of the peace, even if both participants agreed. When might mutual combat avoid criminal charges? There are a few narrow circumstances where a fight might not lead to a criminal case. Again, each jurisdiction, meaning each state or parish, has their own rules and laws. Laws rarely are consistent across the United States, for instance. So definitely know your rights and look up the law in your particular state before you decide what to do. There might be a jurisdiction who has explicit mutual combat recognition. A small number of places, like some interpretations in Texas or Washington ordinances, have legal codes or interpretations allowing consensual fights under specific conditions. In Texas, for example, the defense can argue that both parties consented and knew the risks, and that the fight did not result in serious bodily injury or controlled or lawful activity. For instance, organized fights under licensed or regulated environments like sporting matches or martial arts bouts aren't crimes because participants consent and the setting is lawful. Limited self-defense interaction. In some jurisdictions, if both parties agreed before any self-defense claim arises, the mutual combat concept may prevent one from successfully claiming self-defense later. Jury instructions in places like California reflect this. But look closely. These are defenses or frameworks used after arrest, meaning you would be arrested and then have to try to successfully challenge this. They don't automatically stop police from charging someone at the outset. So when mutual combat does not prevent charges, the black letter reality. Most American jurisdictions do not recognize mutual combat as a legal shield. Even with consent, participants can be charged under various criminal statutes, such as assault and battery. A consensual fight can meet the elements of assault or battery. Prosecutors often pursue charges regardless of an agreement. Breach of the peace or public order offenses. Even if two adults consent to fight, disturbing public peace or alarming onlookers can be criminal. Serious bodily injury or use of a weapon. Of course, a weapon makes a lot of sense, or serious bodily injury. If the altercation results in severe injuries, weapons are involved, or conduct crosses into more serious violence, charges can escalate to felony levels regardless of mutual consent. Self-defense denial. Agreeing to fight generally eliminates the ability to claim self-defense later. Self-defense doctrines require that the defendant didn't instigate or mutually engage before using force. Jurisdictions reject mutual combat entirely. Many states either have no mutual combat law or explicitly ban consensual fights. In Nevada, for instance, merely agreeing to fight is in itself a crime. What judges and prosecutors ask, key legal factors. When a mutual combat defense is raised, courts or prosecutors typically look at the consent. Was the participation truly voluntary, free of coercion, or free of distress or duress? If someone was threatened or pressured, it's not valid consent. Initiation of violence. Who was the first aggressor? Mutual combat defense collapses if the fight was provoked by one side, or if one party tried to withdraw. Serious injury and weapons, as we talked about. The more harm inflicted, especially with weapons, the less likely any consent will protect either party. Public safety and peace. Fights that cause alarm or danger to bystanders can be prosecuted even if both fighters agreed, which makes sense. Case context, why it matters. Even when lawyers successfully argue mutual combat in court, it doesn't retroactively make violence legal. Instead, it may result in reduced charges, alternative sentences, maybe diversion, especially depending on if they have lesser record, dismissals where prosecution credits shared responsibility. But prosecutors and jurors have broad discretion, and consent isn't a silver bullet. So, can a fight ever not be a crime? In rare, narrow, and highly fact-specific circumstances. If you take one thing from this, know that the law is very based on facts. The slightest change in environment, the slightest change in the circumstances of the case can radically alter the consequences that result. So yes, but in most of the United States, two fists flying in fury on a street corner can easily turn into assault, battery, or worse in the eyes of the law. Because mutual combat exists at the intersection of consent, self-defense doctrine, public policy, and criminal statutes, every case turns on its own unique facts. What witnesses saw, what the statute says in the jurisdiction, and how seriously someone was harmed. That's it for today on our topic of mutual consent and how it plays into the whole bigger factor of whether or not a crime will be charged. And ultimately, again, I'm going to do a disclaimer here. This is not intended to be legal advice. This is meant to give you a broad stroke as to what could potentially happen, not for your own personal benefit, but just to kind of understand some of the things that go into the criminal process and some of the legal ramifications that could potentially occur. So thank you for tuning in, and I hope you have a great rest of your day.